Hi everyone, my name is Stacey and today I'm going to be presenting to you Case 9-2013 of the Australian Tax Cases 1-058, which relates to the deductibility of legal expenses and whether the expenses incurred in this case were incurred in the course of gaining or producing assessable income under Section 8-1. I'll start off with the facts of the case. The taxpayer in this case had worked in the financial services industry since April 1997 and held an Australian Financial Services licence. In 2007, he was investigated by ASIC for alleged insider trading offences and was issued a banning order prohibiting him from providing any financial services for a 5-year period. During the 2011 income year, the taxpayer incurred legal expenses totalling $83,000, which related to challenging the banning order before the federal court. As well as this, the taxpayer also incurred $760 worth of expenses trying to defend the criminal charges that were laid against him by the Commonwealth Director of Public Prosecutions in connection with insider trading. At the time that the banning order was issued, the taxpayer had an agreement to provide stockbroking services as an authorised representative on behalf of a group called CPS Capital. On the 7th of May 2010, when a director of the group heard about the ban that was in place against the taxpayer, he notified the taxpayer of his immediate suspension to provide services on behalf of them. On the 3rd of February, the taxpayer applied for a private ruling from the Commissioner regarding the deductibility of the 2011 legal expenses. A month later, the Commissioner issued the taxpayer with a private ruling in respect of the 2011 year, which stated that the taxpayer was not entitled to a deduction for the federal court legal expenses or the criminal charge expenses. Having lodged his 2011 income tax return, making no claim for these expenses, the taxpayer subsequently objected to the assessment issued by the Commissioner. When the Commissioner disallowed the objection, the taxpayer sought review by the Administrative Appeals Tribunal. The issue was whether the 2011 legal expenses were deductible under Section 8(1) of the Income Tax Assessment Act 1997. The taxpayer argued that the occasion of the 2011 legal expenses was defending activities he was undertaking in the course of earning his income as a stockbroker and provider of financial services. In a separate private ruling in relation to legal expenses incurred by the taxpayer in 2009 and 2010, the Commissioner had ruled that the taxpayer was entitled to claim legal expenses incurred in reviewing the banning order, but not expenses incurred in action taken to have his name withheld from the proceedings to review the banning order. The taxpayer had argued that the Commissioner had ruled he could claim a similar legal expense in 2009 and 2010 and was not allowed to adopt a different position in 2011. The decision to be made by the Tribunal is not in dispute that the 2011 legal expenses were incurred by the taxpayer in the year ended 30 June 2011, but rather whether the federal court legal expenses incurred in challenging ASIC's banning order and legal expenses relating to criminal charges are deductible under Section 8(1) of the Income Tax Assessment Act 1997. Section 8-1 states that you can deduct from your assessable income any loss or outgoing to the extent that it is incurred in gaining or producing your assessable income, or it is necessarily incurred in carrying on a business for the purpose of gaining or producing assessable income. However, under Section 8-1(2, you cannot deduct a loss or outgoing under this section to the extent that it is a loss or outgoing of capital or capital in nature, it is a loss or outgoing of private or domestic nature, it is incurred in relation to gaining or producing exempt income, or a provision of this Act prevents you from deducting it. In regards to the deductibility of the federal court legal expenses, the Tribunal held that these expenses were not deductible under Section 8-1 of the Income Tax Assessment Act. The Tribunal stated that it is well established that the words in Section 8-1(1)(a) of the Income Tax Assessment Act, incurred in gaining or producing assessable income, are to be read as meaning incurred in the course of gaining or producing your assessable income. To help with the understanding of when an occasion is deemed to have triggered the production of the taxpayer's assessable income, The case of the Federal Commissioner of Taxation v. Day was referred to by the tribunal. Day, the taxpayer, was an employee of the Australian Customs. He was subject to disciplinary action for misconduct outside the course of his employment. This had severely affected his income as such as an employee. He incurred legal expenses in connection with the disciplinary action. The court held that Day was allowed to claim a deduction. This was held because the respondent's duties as an officer of the service and the possible consequences to him of internal disciplinary proceedings and action with respect to the continuation or termination of his service form part of what was productive of his assessable income in the capacity. The tribunal also stated it is understood that to claim a deduction for a loss or outgoing under Section 8-1(1)(a) of the Income Tax Assessment Act 1997, it is necessary to establish some link or nexus between the loss or outgoing and the production of assessable income, which is often referred to as a sufficient nexus. The tribunal referred to different tests adopted by the courts to help determine whether a sufficient nexus exists in the taxpayer's case. These tests were summarised by Hill J. in the case of the Federal Commissioner of Taxation v. Frith. The first test is the perceived connection test, which states that there must be a perceived connection between the loss or outgoing and the assessable income. The second is the incidental and relevant test, which states that the expenditure must be incidental and relevant to the operations or activities regularly carried on by the taxpayer for the production of income. These tests are only ways of describing the connection that is a necessary prerequisite to deductibility and are only part of the process of identifying whether a particular loss or outgoing is in fact incurred in gaining or producing assessable income. The tribunal decided that under these circumstances it cannot be said that the occasion of the Federal Court legal expenses is to be found in his position as an authorised representative of CPS Capital, as this was a position he no longer held when the Federal Court legal expenses were incurred. Therefore, the tribunal determined that there is an insufficient connection or nexus between the Federal Court legal expenses and the production of assessable income. This meant that the taxpayer was not entitled to claim a deduction for the Federal Court legal expenses for the purpose of Section 8-1 of the Income Tax Assessment Act. The tribunal then needed to determine whether the criminal charge legal expenses were deductible. The court held that they were not deductible under Section 8-1. When determining this, the tribunal took the view that the most likely occasion of incurring the criminal charge legal expenses was to avoid the disciplinary consequences that might follow if the taxpayer was convicted of the insider trading offences under Section 104A(1) and 2 of the Corporations Act. These consequences included potential imprisonment for up to 10 years or a hefty fine. The occasion that the taxpayer is claiming to have incurred these expenses under is determined in fact not to be found in the taxpayer's position as an authorised representative or stockbroker in the financial services industry. By the time the criminal charge legal expenses were incurred, the taxpayer had ceased to occupy any of the employment roles previously mentioned. The occasion of the criminal charge legal expenses were not found to be part of what was productive of the taxpayer's actual or expected assessable income. As I discussed above, this was determined with the help of Hill J. in the case of the Federal Commissioner of Taxation v. Frith. In the tribunal's decision, they determined that these expenses were not deductible under the first positive limb of Section 8-1(1)(a) of the Income Tax Assessment Act. This decision came about as the tribunal found that there was an insufficient connection, link or nexus between the criminal charge legal expenses and the production of assessable income. What are the implications for tax practitioners? When tax practitioners are advising their clients about expenses which are deductible to them, they need to consider the requirements set out in Section 8-1. The questions that you need to ask your clients are, were your expenses incurred in gaining or producing your assessable income, or were they incurred in carrying on a business for the purpose of producing or gaining your assessable income? If your client satisfies the requirements of Section 8-1, you then need to determine that none of the expenses are of capital or capital in nature, that the loss or the outgoing is private or domestic in nature, or incurred in relation to gaining or producing your exempt income, or a provision of this Act prevents them from deducting it. It's important to make sure that all of these areas have been covered before determining whether your client can deduct a specific expense from their assessable income, because you don't want to be giving your clients false information. I hope this video helped in some way. Thanks for watching.